Hi everyone, welcome to this Fieldfisher webinar in which we will walk you through the key decisions of the CJEU of last year. My name is Tim Pankanet. I'm a partner in the Tech and Data team of Fieldfisher Brussels, and I'm joined today by Sixtine Crouzet, Senior Associate in our Brussels office. Hi, Sixtine. So to start, let me make a few housekeeping comments. As usual, we will be recording this webinar and it will be posted on Fieldfisher's YouTube channel, where you can also find the recordings of other webinars that we've done in the past. Secondly, if you have questions, you can type them in the dedicated questions box that you should normally find on the right side of the interface, and we will try to answer as many as we can at the end of the webinar. And then finally, as you may know, this is the second session of our Fieldfisher Brussels webinar series. Last week, we covered the Digital Services Act, and you'll shortly be able to find a recording on the YouTube channel in case you missed it. Our next webinar is scheduled on the 9th of February, where we will be covering data transfers. We also have a few more scheduled in March. For instance, on the 23rd of March, we will be talking about NIS2, DORA, and other cybersecurity regulations. All right, so what do we have on the menu for you today? If we go to the next slide, I will kick off with a recap of the role of the CJEU and provide you with some stats. We will then, with Sixtine, walk you through the key decisions of 2022, and by way of goodie, we've already incorporated the first two decisions that the CJEU adopted earlier this month. And we thought that with that, we had you covered up to speed on everything. While data protection evolves very quickly. Earlier today, actually, the CJEU adopted its third decision. We won't be discussing it extensively, but in case you're interested, it's a quite interesting decision in the context of law enforcement, where the CJEU decided that it is unlawful for police and other public authorities to systematically record biometric and genetic data of accused people in police records. So that will be then for next year's webinar. And to wrap up today's webinar, we will also have a look at which cases are pending and which we may be expecting in coming months. All right, so if we go to the next slide, thank you, Sixtine. I wanted to give a quick recap of how preliminary rulings work and what the role of the CJEU is. And I'll try to be quick because I think most of you will be quite familiar with this, but I think it's important to bear in mind that claimants do not have a direct access to the CJEU in the context of preliminary rulings. And preliminary rulings are the so-called C decisions, so a case number that always starts with a C. In those cases, the court is always called by a member state court. So otherwise said, it always starts with a procedure before a national court, in the context of which a debate arises, a debate around how should certain EU rules, for instance, the GDPR, be interpreted. And if that isn't clear for the national court, well, then that court may decide, and in certain cases it's even required, to refer a question for interpretation to the Court of Justice of the EU. And so the court will then analyze those questions in light of EU law. And it can do a few things. Either it will give an interpretation of how that provision must be interpreted. Think of the concept of establishment, which was addressed in the well-known Weltimo case, for instance. But the court is also regularly asked to assess whether, let's say, non-data protection law, which interferes with the right to privacy and data protection of individuals, whether those laws can be reconciled with the fundamental rights of privacy and data protection, which are incorporated in Article 7 and 8 of the Charter of Fundamental Rights of the EU. Well, if the court then concludes that EU law doesn't stand that test, it has the power to invalidate either a provision or the specific EU law as a whole, which is what it obviously did in the context of the Digital Rights Ireland case, where the EU Data Retention Directive was invalidated as a whole. Now, the CJEU never provides a final decision with regard to the dispute before the national court, right? So it simply explains to the national court how it should apply EU law, and then the national court will adopt its final decision on the merits of the case, which means that the preliminary ruling is binding on the referring court. However, and I think that is really why these court decisions play such an important role in the interpretation of EU data protection law, the decision of the court is also binding on all other national courts before which a problem is raised that is identical. So it's because of that precedent value of its decision that the court plays such a crucial role. And so if we look at some stats, since the adoption of the GDPR, that role is really increasingly becoming important. Data protection referrals have increased massively in recent years. So last year, 27 cases referred, quite similar to the previous year, but much, much more than the years before. And to put these stats even more in perspective, in the 15 years between 1995 adoption of the Data Protection Directive and 2010, there were only 11 cases in total that were referred to the CJEU. All right, so more referrals obviously also means more decisions. If we look at the next slide, there is obviously never a full match between the numbers of referrals and decisions, which is due to the fact that quite often a court will join several cases if they deal with the same treatment and only deliver one decision. But even then, we start seeing rather a similar increase with 17 decisions last year, which is 4 times more than the years before. And then finally, on the next slide, it's noteworthy that a substantial percentage of those decisions are adopted by the Grand Chamber. So that's a chamber where you have 15 judges. That's a lot. So last year, half of the decisions were adopted by the Grand Chamber. And in the last 5 years, that represents approximately 60% of the cases and the decisions it adopted, which in contrast, before the GDPR, so pre-2018, only 25% of the cases were adjudicated by the Grand Chamber. So the conclusion is that understanding CJEU decisions has become essential for basically any privacy professional. And so with that in mind, let's have a look at the decisions of last year, which, as you can see on this slide, we've grouped in 6 categories. Try to cover them thematically, and I now hand over to Sixtine, who will cover the first category.
Thanks, Tim. So let's start with the first category, which is GDPR definitions and principles. So we selected 2 decisions for this big theme, and the first one deals specifically with the definition of sensitive data, so special categories of data. In this case, there was a national law requiring certain individuals working for certain entities, publicly funded entities, to file a declaration, so what is called a declaration of private interest. And in this declaration, individuals would provide personal data relating to them, but also relating to their spouse and partner. And so in this particular proceeding, there was an individual who was a man who was filing this declaration and providing personal data on his partner, who was also a man. And so the question of the referring court was, what is the nature of the name of the partner in this specific case? Is it sensitive data? And to respond to this question, the Court of Justice gave a particularly broad interpretation of what it means to be a special category of data. The court said that obviously Article 9 of the GDPR covers data that is inherently sensitive. So for instance, disclosing that you're openly gay is obviously sensitive data, but it also includes any data, and here I quote the court, that is liable indirectly to reveal sensitive data. And so with this broad finding, the court concluded that in this case, since you're able to deduct with the information, so with the name of the partner, that the declarant, so the person filing the declaration, was gay, so you could basically infer his sexual orientation, and therefore the name of the partner was in itself sensitive data. And so now with this broad finding, a key takeaway would be to reassess on a case-by-case basis, of course, the personal data that you're processing, to make sure that even indirectly does not disclose sensitive data. Of course, the decision of the court does not only apply to sexual orientation, but it applies to any kind of data that would reveal political opinion or religion. But then it also doesn't help, because the court doesn't really say how far the assessment should go, and whether it's likely that you can deduct information. So again, it's a case-by-case basis, and this ruling also raises a lot of questions. Now, if you turn to the second decision, so in this decision, the court interpreted two principles of the GDPR, which are the principles of purpose limitation and storage limitation. The context was very specific. We had a telecom operator which had a customer database to perform the contract with these customers. And then this operator detected some technical bugs. So to remedy that, this operator decided to replicate parts of the customer database into a second database to run tests and to fix these technical problems. So the refereeing court had some questions around which roles, which GDPR provisions were applicable to the second test database. And so basically the Court of Justice was asked to clarify the regime applicable to the test database. And the court says here it's clearly a case of further processing, because you had the first customer database, which was set up to perform the contracts with customers, but then for a second purpose, which was to run some tests, this controller created a second database. So it's clearly a further processing activity, and therefore the regime in the GDPR applicable to further processing applies, and the controller needs to check whether the further processing is compatible with the initial processing. The court leaves it to the national court to decide whether it's really compatible in practice, but it does give some useful guidance, and the court suggests that actually there is probably a compatibility between the two purposes. So I'm just going to give some example. The Court of Justice relied on the criteria to assess compatibility in the GDPR, and in a nutshell, it says that here there is a direct link between the two purposes, and it doesn't seem to go beyond the expectations of the customer. And apparently there's no special category of data or sensitive data in any way. So it might be compatible, but it's still for the national court to check. So that's an interpretation of the principle of purpose limitation. And then the court recalls the principle of storage limitation and says, well, in this case, you also have to comply with this principle and to delete the second database once the purpose has been achieved. And this was not the case in practice, because the telecom operator kept the second database for too long in this particular case. So a practical takeaway would be to take this decision into account, because it often happens in practice that in big organizations you have a main database that is then replicated across different systems, different applications or software. And so in each case, you would have to assess the compatibility of the second or third database to ensure that it's lawful. And of course, each database needs to be set to be deleted after a certain period of time. Now we can discuss the second theme. So no, sorry, still on this theme. So the last decision of this theme. Here, the court still interpreted the general principles of the GDPR again in a specific context. So we had a national tax authority requesting a website publisher to provide some data about its users, and in particular to provide personal data relating to users selling items on the website. And the website publisher was challenging this request for information, saying that the authority did not comply with the GDPR, and in particular, it went beyond. It requested much more data than was necessary. So the refereeing court was asking the Court of Justice which rules apply here to the authority. And the court recalled, but it's no surprise, that the GDPR applies to the specific request. And so the tax authority has to comply with the GDPR, and in particular with the principles of data minimization, storage limitation, and purpose limitation. And so then the decision really focuses on the obligations of the tax authority. But what's interesting as well is that the court does say that the GDPR applies to both processings, because there are two processing activities here. First, the collection of the data by the tax authority from the website publisher. But then on the other hand, you have the disclosure of personal data by the website publisher to the authority. And so both processing activities need to comply. And so in this case, the website publisher had, as well had to comply with all the GDPR principles, and it needed to make sure that it didn't disclose more data than necessary. So a key takeaway here would be to each time you receive a request or an order from authorities, you have to make sure that you comply with data minimization. And if you have any doubt about the lawfulness of the request, you can always challenge the request and ask the authorities to justify their compliance with the GDPR. In practice, a lot of organizations already have integrated this, and they have drafted internal policies to handle orders from authorities. So it's applied in practice, but it's still a useful reminder from the court. So now back to Tim for the second theme.
Yep, thank you, Sixtine. So we have three decisions that deal with data subject rights that we would like to discuss. And the first one is the Google case of end of last year. In that case, a data subject had requested the dereferencing of a link which contained information about that individual, which the individual claimed was inaccurate. And it's interesting to know that the data subject had not taken any action yet against the actual content provider to rectify the information in the alleged article itself. And so the court did an interesting analysis here and decided a few things. First of all, the court clearly stated that the data subject is not required to have started action against the actual content provider, let alone that it should have obtained a judicial decision which confirmed that the information was indeed inaccurate. That's not required. It suffices, says the court, that the data subject provides reasonable evidence that the information is manifestly inaccurate. On the other hand, interesting for online platforms and search engines, the court specifically recognized that it would be too burdensome for a search engine like Google to actively try and find evidence as to whether the information is inaccurate. So there is no proactive or active obligation for these platforms to try and assess the validity of the claim of the data subject. It can simply rely on the information that the data subject provides them with. And then finally, and I think this is perhaps the most interesting element of the case, the data subject was actually not only asking the dereferencing of the link to the actual article, that article also contained a picture of the data subject. And so in Google Images, a thumbnail of that picture, of that photo, was also included. It only showed the picture, not any text about what was in that article. But obviously, if you clicked on the photo, you were then redirected to that specific article, which, according to the data subject, contains inaccurate information. And here, the Court of Justice really did an interesting analysis, because it decided that the dereferencing of the link to the article, when that is granted, well, actually then the display in the image search of those photos in that article must also be dereferenced because, and I'm quoting the court here, the practical effect of dereferencing the article would be compromised since internet users would continue to have access to the entire article by virtue of the link contained in the thumbnail. So the fact that you can still click on the photo. So a quite extensive interpretation there, where the court really looked at what the actual objective and purpose is of the GDPR, the right of the data subject, the right to be forgotten, and therefore concluded to this quite broad interpretation. So even if the case is quite specific, obviously, to the context of search engines, I think this last bit is quite interesting because of this broad interpretation that the court has given to the notion of right to erasure of online data. If we then look at the second decision that deals with data subjects, it's the Österreichische Post decision, one of the decisions of this year, January 2023. And the facts of this case were the following. We again have a data subject who had requested access to its data, including information on the identity of the recipients of its data. So we had a data controller who had shared the data subject's data with third-party recipients, and data subject wanted to know who those recipients were exactly. In the response that the data controller gave, it only provided information on the categories of recipients. It did not disclose their actual identity. Now, as you probably know, Article 15 of the GDPR states that the data subject has the right to obtain, and I quote, the recipients or categories of recipients to whom personal data basically has been disclosed or will be disclosed. So both are in that Article 15, and the Court of Justice acknowledged the fact that Article 15 gives this choice and even goes further by confirming that Article 15 does not create an order of priority. It's really a choice. However, and a bit similar to the previous case, the court again examined the objective of the right of access. And it really concluded that the right of access is a crucial prerequisite for data subjects to be able to exercise their other rights, for instance, the right to object, the right to rectify data, etc. And so therefore, in the context specifically of Article 15, when the data subject expressly asks for it, the controller is required, according to the court, to provide the actual identity of the recipients of data. Two exceptions to that general rule, according to the court. First of all, if it is impossible to identify those recipients, to be honest, it's not entirely clear to us in which scenarios that would happen, but it seems to be the scenarios where the controller will be disclosing data in the future, but it does not know yet exactly to whom it will disclose it. But so in those cases, it can rely on the exception. Secondly, it can rely on the exception if the request is manifestly unfounded or excessive. So that's the general exemption that is foreseen in Article 12, paragraph 5 of the GDPR. In those two cases, obviously, the data controller will still be required to provide info on the categories of recipients. So not the actual identity, but still the sort of more general information. Now, as you will have understood, this is a quite far-reaching decision, which certainly requires controllers to update their policy and process internally for dealing with DSARs. This nuance needs to be added, that if a data subject specifically asks for the identity, you have to comply with that request. That's one takeaway. The other interesting point, which unfortunately is not entirely clear, is the following. Does this decision also require a controller to identify the recipients in the privacy notice? Here we've been talking about Article 15, right of access. In Articles 13 and 14, let's call them the privacy notice articles, there you will find the same wording, also the requirement to provide information on the recipients or categories of recipients. The court is not entirely clear, but again, if you look at this objective, the analysis of what is the perceived objective of Article 15, I think it's a bit different with a privacy notice. So our view is that at this stage, the court has not decided as such that all privacy notices should also contain the actual identity of recipients. You could still only provide information on the categories, but it is not fully addressed because Articles 13, 14 were not part of the actual questions referred. So it can unfortunately not be excluded that in the future, specific questions about those articles are referred to the court, and that the court would, again, there as well, then apply this same rationale. But for the time being, our take is that privacy notices can still rely on categories of recipients approach. Okay, and then the final decision about data subject rights is the Proximus case. In that case, there was actually an individual who had requested a provider of an online phone directory to remove its contact details. It's a quite specific case, a point that is specifically covered also in the e-privacy directive, because actually the provider of these directories had received the data subject's contact details from the telco operator of that data subject, and had subsequently also shared that data with other providers of publicly available phone directories. And that was done based on, let's say, a single consent. And the court analyzed really these factual elements and came to the conclusion that actually all these three independent controllers, so the provider of the directory that was part of the proceedings, the initial telco operator, and then let's say the provider that's received subsequently the contact details, that all these three independent controllers were basically relying on one and the same consent that the data subject had provided. And again, we know that consent has to be granular, and this may sound a bit strange, but this is really driven by this specific e-privacy directive provision. And so, having concluded that there was one and the same consent from the data subject, the court said that because the data subject was basically withdrawing its consent, that the provider of the phone directory service was required to also inform the other independent controllers that were processing the data subject's data in their directories. So the initial telco provider and also the subsequent directory providers. And so the key takeaway of this decision, although it's obviously very specific in the telco sector, is that whenever a data subject withdraws its consent, or if you receive a right to erasure for online data, you should verify whether you are required to inform other controllers who are also processing that data, potentially beyond the cases that are specifically covered by the right to erasure article. So here the court, in a way, expanded that interpretation and application of this principle. And with that, I hand back to 16, who will discuss the decisions that deal with remedies.
Thanks, Tim. So we have two decisions regarding remedies, and the first one involving Meta. This is a decision coming from Germany, where basically we had a consumer protection association who brought proceedings against Meta, and this proceeding was based on consumer law. And the association was arguing that Meta infringed several provisions, including data protection provisions. And so the question of the referring court was, did this association have standing, and was it allowed to bring this civil lawsuit without any mandate? Yeah, I didn't mention it before, but basically there was no mandate from any data subject, so it was really an ad hoc lawsuit. And so here the court had to look precisely at the different mechanisms in the GDPR with and without mandates. So here there are two important provisions of the GDPR that could apply. The first one is very well known. It's Article 80, paragraph 1. This is the most applied in practice. It's basically that associations can bring proceedings with a mandate of data subjects against controllers or processors. And for instance, we often see that NOIB, so the NGO, None of Your Business, brings frequently proceedings with the mandate of at least one data subject. So this provision did not apply to this case because there was no mandate. But basically what is a little less known is that there's a second paragraph in the same article. So Article 80, paragraph 2, which basically allows member states to provide for representation mechanisms without mandates. So it's not automatic. It's a margin of discretion of the member states who are free to enact laws allowing associations to bring proceedings without a mandate. And so the court, what the court did is that they analyzed the German consumer law at stake to determine whether this law fell into this margin of discretion. And to do that, the court interpreted the GDPR provision, and it gave a very broad interpretation of this provision. In a nutshell, the court concluded that the German national law did fall into the margin of discretion of Germany. And so basically, the association could validly sue Meta without a mandate. And to do so, the court said that basically this mechanism has really a preventive role. And so it's not necessary to prove an actual harm or to prove that there was a specific infringement relating to a specific data subject. It was just sufficient, and here I quote the court, it's sufficient to claim that the data processing concerned is liable to affect the rights of data subjects. So it's a very broad statement, and it basically means that a lot of national laws could potentially fall in the scope of this provision. And what was interesting in this case is that the German law at stake was actually adopted before the GDPR, but still the court found that it fell into the margin of discretion of the GDPR. And so, yeah, I guess a practical takeaway would be that to really assess the risk of private enforcement, now companies also have to take into account this, and they should analyze, depending on the country and the member state where they operate, whether such country allows for such representation mechanisms without a mandate. Because if that's the case, then the risk of private enforcement would be significantly increased. Then going to the second decision on this topic. So it's actually a decision that was delivered a bit earlier this month. So you probably saw it. In this case, we had a data subject who exercised his right of access. And then he considered that the controller did not fully comply with his right of access. So he decided to lodge a complaint with the national DPA, which rejected his complaint. And so as he was unsatisfied, he appealed that decision of the DPA before the administrative court. But in parallel, he also initiated a civil lawsuit against the controller before the civil court. So we had two sets of proceedings in parallel, the administrative one and the civil one. The civil court was the first to hand over a decision. And so the administrative court referred to the Court of Justice to ask, well, now we have a civil court decision, but are we bound by the findings of the civil court, or are we free to decide something else? And so the question was really on the relationship between the different remedies that the GDPR provides for the data subject. And so the court looked at the different remedies before national courts. And so it found that basically there was no priority between the different court decisions and no precedent value of one decision over another. And so these proceedings could be exercised independently and concurrently. So that's an important finding. But obviously, this creates a risk of inconsistency if the civil court decides something and then the administrative court decides otherwise. And so the court did recognize that there was a risk of inconsistent decisions for the data subject, but it did not really provide a solution. It just stated that each member state is competent to enact national procedural rules to protect data subject, but it did not give a clear indication of on how national member states could ensure that there would be no inconsistency. So it does raise a lot of questions, and as a key takeaway, controllers and processors should be aware that they can be subject of parallel lawsuits with the risk of inconsistent decisions. And so as part of the litigation strategy, it should be integrated that you should find ways to reduce and mitigate the risk of inconsistencies between the different proceedings. And now back to Tim.
Yeah, thank you very much, 16. So I will now cover two decisions which are good illustrations, let's say, of how the Court of Justice is requested to assess the interference of so-called non-data protection laws with the fundamental rights of privacy and data protection. And the first case caused quite a stir in the financial sector. It's the Luxembourg Business Registers case, where the Court of Justice was asked whether the fifth AML directive, which essentially or partially requires member states to allow the general public access to the ultimate beneficiary owner register, so the UBO register, whether that requirement was compatible with Article 7 and 8 of the Charter of Fundamental Rights, so the rights to privacy and data protection. And the court examined the objective of this provision in the AML directive in quite a lot of detail, and concluded that the object of increasing transparency towards the wider public in view of obviously reducing things like money laundering and terrorist financing, obviously that was an interference with the rights of privacy and data protection of those UBOs. And so then the question is that interference allowed? So if you have this clash between certain fundamental rights and legal provisions that potentially interfere with the rights, then the court needs to assess whether the interference can be justified. Because, and that is important to bear in mind, and something I assume you probably know, fundamental rights in general, but right to data protection and privacy in particular are not absolute rights. There's a lot of limitations and interferences that are possible and can be justified. And so in this particular case, the court decided that the interference was actually not strictly necessary to achieve the purpose, the objective of the AML directive, and based on that conclusion, it had no other choice than to invalidate that specific provision. And so the consequence is that no longer today it is possible for the general public to get access to the UBO registers in the different member states. So member states need to reconsider their approach to that access. And for instance, in Belgium, the draft act to address this issue is currently being discussed in Parliament. And it seems likely that across the EU we will see intervention from member states legislators where the access will be limited to those entities that are really subject to the preventive AML and KYC checks, and that the wider public will not or no longer have this general or access, or that they may need to justify why they would like access. So so that is one example. The second decision is a decision in a similar context and with a similar outcome. Here, the court was asked to examine the compatibility of certain reporting obligations for lawyers under the DAC 6 directive. That's a finance directive or tax directive, I should say, which aims at basically avoiding aggressive tax planning and tax evasion, to keep it simple. And so here again, the question was whether that reporting obligations for lawyers could be justified. And so the court analyzed the objective of this law, which was avoiding this tax evasion and aggressive tax planning. But it also looked at how this reporting obligation interfered with clients' attorney legal privilege, and so therefore interfered with the right to privacy and data protection of the clients of these lawyers, who would ask their lawyer to set up potential cross-border tax schemes. And having done that analysis here, the court came again to the conclusion that the interference was not strictly necessary. The objective essentially of the DAC 6 directive, in the words of, or in the view of the court, could have been achieved in other ways without obliging lawyers subject to legal privilege to make these specific reportings. And so here as well, the court had no other choice than to invalidate the specific article of the DAC 6 directive that dealt with the reporting, that specific reporting obligation for lawyers. So that brings me to the next case, which is a special one because it's the only decision that is not a preliminary ruling, but a decision following an action for annulment. And you can tell by the fact that the case number it's not a C case, it is a T case. So what is the context? And I assume you probably heard about it, but essentially we had the Irish DPC who was doing an investigation of WhatsApp, and the other supervisory authorities concerned and the DPC were unable to reach a conclusion on the DPC's draft decision. And so what happened, the case was escalated to the EDPB, who had to adopt a binding decision. And in its binding decision, the EDPB concluded that certain GDPR infringements had been committed by WhatsApp, which the DPC then had to integrate in its enforcement decision on WhatsApp. Now, as a defendant, and that's important to bear in mind, WhatsApp was not formally party to that binding decision procedure, was not formally heard by the EDPB, because it's not a contradictory procedure as such, at least that part. And so what happened, WhatsApp wasn't happy with the binding decision of the EDPB, and so it filed an action for annulment against that decision because essentially it disagreed with the conclusions of the EDPB. Now, based on pretty much EU procedural law, the court came to what we could call a logic decision, although in my view, the outcome is slightly unfair. So what did the court do? It assessed, first of all, that, or it came to the conclusion that WhatsApp did have a judicial remedy before the Irish courts against the DPC decision. So its right of defense and the right to fair trial and appeal were not affected, because if it disagreed with the EDPB decision, well, that was reflected in the Irish DPC decision and that was subject to appeal. Secondly, the court concluded that the decision, the EDPB decision, did not have binding legal effect on WhatsApp individually. So although obviously WhatsApp was directly concerned by that binding decision, the decision itself did not create a binding legal effect on WhatsApp. It was only binding upon the Irish DPC, who had to adopt a decision that was aligned with the conclusion of the EDPB's decision. And so based on these considerations, the court pretty much didn't have another choice, I think, to dismiss WhatsApp's action as being inadmissible. And again, it's sort of a logical outcome from a procedural point of view, but I think it's still, as from a principal approach, quite problematic that the dispute resolution mechanism in general, which as it is currently foreseen in the GDPR, that it is such a black box, I would dare to say, for defendants. Obviously it also means that when you become aware of this binding decision of the EDPB as a defendant, if you disagree, you have to sweat it out and wait for the actual decision of your DPA. So you lose potentially a lot of time, potentially impact on your reputation, etc. So I think it's quite unfortunate that this mechanism, this one-stop shop mechanism, has these consequences. All right. So then finally, and very briefly, I wanted to let you know that the Court of Justice also adopted 5 decisions about access to traffic data by law enforcement. So traffic data that is retained by telco providers. 5 decisions. I won't address them in detail, and for those of you who are active in the telco sector, I hope you'll forgive me. The reason why I'm not doing it is because these decisions add to the substantial body of case law that we already have on this matter, and you may know that the court not that long ago adopted their last 2 landmark cases, because we've had so many decisions on retention of traffic data in the past, but the last 2 landmark decisions are La Quadrature du Net and Privacy International, and in these 5 decisions of this year, essentially the court only reconfirmed the key findings of those 2 landmark decisions, which in essence is still the fact that a legal obligation which imposes a general and indiscriminate retention obligation of traffic and location data onto telco providers is not lawful. And so for those of you based in Belgium, you may know, as a result of La Quadrature du Net, that Belgium had to adopt a new retention regime for traffic data. There has been a lot of criticism about that. It's supposed to address this issue of general and indiscriminate retention. It's far from sure whether the way in which it has been implemented in the new law, whether that does reply to the requirements of the Court of Justice. And so it will be interesting to see, also based on these 5 decisions, which continue to confirm the principle, whether the Belgian new version will ultimately pass the test of judicial review. Voila, I think with that, I can hand back to you, 16.
Sure. So unfortunately, we had to leave out some decisions. As Tim said at the beginning, we had around 17 decisions last year, which is quite a big number. So we won't talk about these few decisions, but we set out the main theme. If you had given this webinar a few years ago, we could have talked at length about the few 5 or so decisions delivered, but this is not the case nowadays. And now, what awaits us next in the next year or so? As Tim said, there's now a steady flow of referrals going to the Court of Justice. And so this translates into a heavy backlog for the Court of Justice with 49 pending referrals. So it's very likely that the court will deliver quite a big number again of decisions in 2023. And yeah, when we look,
sorry to interrupt, 16. I should actually, given that we had a decision today, the backlog has reduced to 48. So as you can see, it's really hard to stay up to date in these matters because things evolve that quickly.
Okay, that's a relief. So 48 to go. And when we look at all these pending referrals, we can see that there are some predominant themes. And in particular, we had a lot of referrals which touch upon the GDPR provisions on complaint, remedies, and compensation. So we have 5 specifically on the right to lodge a complaint before the National Data Protection Authority. And even more than that, we have 8 on the right to compensation. And here, I have to say that we have a lot of different questions for the court to interpret the conditions under which data subjects or other persons can be granted a right to be compensated. So for instance, we have questions around the notion of non-material damage. So what does it mean, non-material damage? Is it enough to have fears or anxieties? Is there a de minimis threshold to be compensated? Must there be an infringement of the GDPR? So a lot of questions as well on how much the compensation should be, what purpose the compensation serve, is it punitive, for instance? So a lot of interesting questions, and for sure the court will shed some light on this provision. As I said, some referrals on administrative fines. Two specifically on profiling, where it could be interesting because there's no so far guidance from the court on this topic. Specifically on the notion of automated decision making and profiling, and also in particular when you have to inform data subjects about profiling, what does it mean to provide meaningful information about profiling? What if you have trade secrets as well? So a lot of interesting questions. We still have a lot of referrals on the right of access, so maybe to as a follow-up to the case that Tim was describing before on the scope of the right of access. And lastly, we have no referral on international data transfer. So it looks like we won't have a Schrems 3 decision, at least for in the short term. Yeah, and then back to Tim.
Yeah, I think that's a good addition that you made there. I wouldn't be surprised that we will have a Schrems 3 decision in the future, but it's indeed interesting to note that despite all the attention that there always is around international data transfers, that currently none of the questions deal with that topic. So at least for the time being, let's say, it seems that for the national courts, it's clear how the rules should be interpreted, despite all the questions that you could ask around transfer impact assessments and how to do that in practice. So yeah, it'll be interesting to see how that evolves, and obviously with the new EU-US transfer framework, what the impact will be then. With that, we've come to the end of this webinar. If you have questions, we still have a few minutes to take them. So feel free to type them in the chat box. Wanted to just signal two useful resources in case you really taken the taste of analyzing Court of Justice decisions. Those of you who know me know that for the last couple of years I've been keeping track of pending data protection cases at the Court of Justice through the database DP Curia, which is freely accessible, also allows quite easy searches around specific topics. So if you ever need to check certain things, feel free to check it out. And with 16 and some other colleagues and the team, we drafted an case law review on the data protection decisions of the court between 95 and 2020. That as well is freely accessible on DP Curia, and obviously as we are getting so many decisions, we will certainly have to draft an updated version or a complement to that case law review in the foreseeable future. So with that, just a few questions. Let us have a look. 16, I think. So I saw there is one question about sharing of data with authorities. So in case of a formal request for information of a regulatory authority, is there room for a DPA, data processing agreement, between the authority and the controller who provides the data sets, or not? It's a good question. In essence, I think the answer is it will be difficult, and probably it's not needed to put in place a DPA, as at least not a data processing agreement in the sense of Article 28, because normally that public authority will be a data controller in its own right. So the transfer will be a transfer between two data controllers, independent controllers, and GDPR does not require specifically for that kind of transfer that an agreement is concluded. It's always a good idea in practice to put something in place, a controller to controller sharing agreement. However, let's be realistic, and at least also based on our experience, it's practically, I would say, almost impossible to put that in place when an authority asks for information. My guidance or recommendation would be more to focus on the extent to which the request is founded in the law, whether they are allowed to oblige you to provide information, and whether it's not a fishing expedition, but to the comments that 16 made, that the request is complying with principles like data minimization, for instance. I think those are the 2 points that I would focus on most. Do we have other questions, 16?
So there is one. So I think this is a follow-up to the right of access case that was delivered a few weeks ago. So what if the recipient of the data is an individual? Can data subjects now see the name of the person to whom an email about them is sent?
Okay, yeah, that is indeed an interesting question. Sorry, go ahead.
So actually, I think there's a pending referral on this specific topic. So not this specific setting, but on the notion of recipient and whether physical or natural persons, the identity of natural persons should be disclosed to an individual exercising his or her right of access. And if I'm not mistaken, there was an opinion of the Advocate General a few weeks back stating that if you exercise your right of access, you cannot see which individual persons had access or saw your data. Because, for instance, in this case, it was a bank. So the employees of the bank accessing your data are working, under the authority of the controller, which is the bank. And so they're not third party. They don't have a data protection role under the GDPR. So it was not in the scope of the right of access. So if you want to read that opinion, I think it would be interesting.
Yeah. No, absolutely, yeah, just bear in mind that the court doesn't always follow the opinions, of course, but yeah, it's an interesting opinion. I think just one additional comment that I would make on this. I think potentially, if the individual is a third-party recipient, so not working under the authority, I think the implications of the Austrian Post decision would indeed be that if the data subject asks the actual identity, that you may be in a position where you have to disclose the identity of those individuals, unless, of course, and that is the sort of general caveat, unless in doing so you would adversely affect the rights of those third-party recipient individuals, because that is the general exemption in Article 15, I think the last paragraph, which gives you a way out. You can ignore a right of access if the rights of third parties would be affected, but obviously you will have to justify. So it's not something that you can or will be able to do in every single scenario. Okay. Let me see. I think we have reached the hour. I don't see other questions at this stage, so I think we can probably wrap it up here. We hope you found this interesting. It's yeah, not the most sexy topic for a webinar, of course, but as we mentioned, it's a very important one, and so hopefully you've now been entirely caught up and ready to ramble on your internal exciting privacy challenges in line with how the Court of Justice views the GDPR. So thanks a lot for attending, and yeah, hope to see you at one of our next webinars.
Thank you.